Hi, we're back with the second hour of Justice for All. I'm George Yates, 1650 AM, and I'm back with Harvey McGregor, Queen's Counsel. Hello, Harvey. Are you there?
Yes.
You are.
I've been listening to all those terrible ads.
Yeah, well, that's how we pay for the hour. Listen,
I understand.
You are a Queen's Counsel. What is a Queen's Counsel?
Well, the Queen's Counsel is a top barrister, called a Queen's Counsel when we have a queen, a King's Counsel when we have a king, and it's like you only become a Queen's Counsel when you're fairly mature in your 40s. But you have to apply, and many people apply and don't get it. It's not very clear how they make the decisions, but the authorities make the decisions, and some people do get it, but they have to apply. It's done annually, generally in April. So you can apply 1 year, and if you don't get it, you can apply the next year. And some people apply 3 or 4 years or 5 years before they get it.
How do you...
in my case, I managed to get it in year one, as they say, the first time of asking.
How do you... what distinguishes... I know we've talked about what a solicitor is and what a barrister is. Can you get back a little bit from the mic, Harvey? Because we're hearing that's
yes,
better.
All right.
That's better.
I'm moving it quite a long way from the mouth, yes.
You're right.
Go ahead.
Can anybody become a barrister? Do you have to apply for that? We talked earlier about solicitors and barristers.
You've got to take your bar exam. You have to pass your bar exams.
Well,
I'm sure that's the same in the States.
Right, but doesn't a solicitor have to also pass a bar exam?
No, he has solicitor's exams. They're different.
They're different. So
and they cover different. Well, they cover different things. I mean, they cover things like estate planning, and I'm not sure exactly what they do cover, but they cover the sort of things solicitors do, as opposed to things barristers do.
And so barristers take a separate exam then that asks them about evidence and trial practice and all that sort of thing.
Yes, and they go through the various subjects. I mean, it's such a long time since I took my bar exams, I've rather forgotten exactly what the papers were all about, because I took my bar exams in 1953, I think.
Now,
and that is, as you can see, 60 years ago.
Have you had an active trial practice in addition to you being an educator? Have you tried cases
yes, I have.
To judges?
I managed to combine the two.
What's your?
I got the idea from the States, because I found that there were quite a number of senior professors who appeared in the Supreme Court, and I thought I'd try and combine them here, because I was interested in both the academic side and the in the practicing side. And when I came back from the States and said this was my plan, everyone said, they said, it'll never work. You can do that sort of thing in America, but you can't do it here. Anyhow, I have proved them wrong, and I was the first person to combine the two. There are more now, but again, as I say, I started 60 years ago.
Well, I thought we would have a little fun over the course of the next hour then. If you're at a cocktail party with some other barristers, what would be your favorite war stories to tell about some of your trials?
Oh, I find that very difficult.
I mean, what was your biggest verdict? What's your largest verdict that you've received, let's say, or a case that you lost that you thought you should have won, or a case you won you thought you might have lost? Well,
I had one of my big cases. This has nothing to do with loss in fact, it was finally lost, was this was what propelled me into fame, if you like to put it that way. There was a television mast fell down, and when I say a television mast, I mean one covering the whole of the north of England. So it was over a mile high. And it fell down in a rather light snowstorm. In fact, it may not have been any snow. There was a slight wind, but it just collapsed. And fortunately, there was nobody about at the time. It was, I think, about 7 in the morning. So no one was injured or killed. But of course, those that owned the mast sued the constructors for negligent that they'd built it defectively, and there was an enormous amount of evidence as to why it had happened, and there was a question of what the damages would be, and I was just brought in on the damages front. I wasn't a Queen's Counsel at this time. I was just, if you're not a Queen's Counsel, you're normally called a junior. You're junior counsel. That's got nothing to do with your age. I mean, if you don't become a QC and you're still you're still at the bar at the age of 50, 60, you're still a junior. You're a senior junior, if you like. Anyhow, that's by the way. I was brought in on this case. There was a QC handling the case in the non-damages part, which was the main part, to decide whether there was negligence and defective building, which needed a lot of expert evidence. The case lasted 3 months. Anyhow, this QC, who was a fairly new QC, fell ill, or he said he fell ill, just before the case began. And I think he was a bit worried about the case, but the judge very kindly gave a week's adjournment. It was going to begin the following Monday. It was starting on a Monday. And on the Thursday, Friday of that week, the solicitors who were running the case came to me and said, "We have lost all confidence in our QC. We want you to take over the case." So I had to take over the case, and I had expected only to deal with damages and only just to sit behind this QC while he argued the whole thing. And so I took it on, and I had to cross-examine lots of witnesses, and I turned out to be very good at it. But I had to get up at 2 o'clock every morning to get the case prepared, because at the end of the day, the judge will say, "No doubt you can answer this question in the morning, Mr. McGregor," and you have to find out what the answer is, and generally put the case together in your argument for the day. Anyhow, it went on, and then I made a final closing speech, which you do, and I'm sure you do it in the States as well, and it was a very elaborate one. It lasted 11 days. So
your closing argument
propelled me into fame.
You had an 11-day closing argument?
That's correct. Not bad.
What in the world? 11 days? How in the world can you go 11 days on one subject?
Well, there were very features to it, but I think I still have a copy of my closing speech. Perhaps I ought to send it to you. It's not quite as long as McGregor on damages.
I was about to say, anyone that can write a 2,000-page book ought to be able to do an 11-day speech.
Yes. Well,
and did you win the case? Did you get a good verdict for damages?
No, we lost the case. We lost the case. I felt that when I opened my closing speech, that we were in difficulties, because I opened it by saying accidents can happen, that without necessarily anyone being negligent in any way. This mast, this could be the case with this mast. And the judge said, but it fell down, didn't it? And I thought, oh dear, he's thinking if it fell down, somebody must be responsible. So the decision went against us. But that didn't matter. I had made my mark.
You were defending the owners of the mast.
Yes, I was. I was defending the constructors of the mast.
Right.
The owners of the mast were the plaintiffs.
And this
their mast had fallen down, and they said to the people who built it, "You've built it defectively, otherwise it wouldn't have fallen down. We want damages." And the damages were very high because it would require reconstructing the mast and all sorts of effects on their television programs throughout the time this was happening.
And you were a junior counsel at the time.
I was a junior counsel at the time, and not as a result, but partly because of that, I managed to apply for silk the next year and got it.
Became a Queen's Counsel the following year.
It's very complicated now to become a QC. You've got to apply, and you've got to pass the various exams you've got to take. In the old days, you just had to have two referees who spoke highly of you. So I managed to get the judge in this case, who wrote a very good reference, and I also got. We have a body called the Law Commission, which deals with reform, and the head of that, Lord Scarman, I got him to write one too, and I got silk, as they call it, QC, the following year.
We're here with Harvey McGregor.
And so
we're on Justice for All, 1650 AM. We're here with Harvey McGregor. He's the author of McGregor on Damages, which is the premier book on damages in the Commonwealth nations. Tell us a little bit about, you've also taught law around the world. You were talking about Japan and India and Canada as far as the law of damages in those countries. What difference is there in damages law in these other countries as compared to England?
Well, the Commonwealth countries like Canada and Australia and New Zealand and others follow English law to a very large extent. They have different legislation, obviously. And as you know, common law is based on case law, as they say. It depends what cases were decided. We have this so-called doctrine of precedent, that once a court has decided a matter, then it's binding on future courts. That issue has to be decided the same way. And therefore the cases are very important. You're always citing cases when you're arguing your own case. And of course you cite cases in England. Well, the cases in Canada will be different. But, I mean, key cases, for instance, key issues, for instance, they'll have one case in Canada covering it and one case in England. In fact, it might even be similar in the States. I mean, for instance, the rule that there used to be a rule that you could only sue somebody if you were injured by a product of theirs. You could only sue if you had a contract with them, and of course, quite often the fault would lie in the original manufacturer. that the manufacturer sells it to a supplier, who sells it to a wholesaler, who sells it to a retailer, who sends it to who sold it in a shop. We have a very famous case in which and if you didn't have a contract with any of these people, you couldn't. There was one way you could probably sue the retailer, and he could sue all up the line. But this person didn't have a contract with the retailer. It was a case which is well known here about a lady in Scotland who went to see a friend in an adjoining town, and they went to a cafe, and they wanted to have a drink of beer or something like that, a bottle of whatever, and the friend went and bought it, so that the other person didn't have a contract, and she discovered there was a snail in the bottle and in her glass, and she was pregnant at the time, and she suffered nervous shock, and she may have lost a child, but she was psychologically injured by this, and it was held that she could, although there was no contract with her, she could sue the original manufacturer who had put the snail in the bottle. Now, it's called Donahue and Stevenson, 1932. There's an equivalent case in the United States called McPherson and Buick, which was earlier, 1916, which is exactly the same. The person, I'm not quite sure of the facts of that case, but they were suing Buick, who had manufactured the car, and it had come down through a whole list of people. So the principle that you can go right back to the manufacturer has got one case in this country, probably the most important case of the last century in tort, and you've got a similar case in the States. You will have a similar case, no doubt, in Australia and in Canada and in New Zealand, etc. I can't really tell you very much about what the Japanese law is. All I know is that the Japanese are very interested in English law. Otherwise, they wouldn't be reading my book. But in fact, I met one Japanese chap. I may have told you this when I talked to you earlier. He at an international conference, and he came up to me and he said, in his sort of quiet Japanese way, he said, "You are a legend in Japan." Now, that's not bad, is it?
Not bad, not bad. So that's your book. When you talk about precedent, your book can be cited as not controlling authority, but it would be persuasive authority, even outside.
Oh, yes.
You could use that as persuasive authority if you couldn't find a case exactly on point in American law. You might well find McGregor on damages and get an American judge to go along with it because there's no controlling case in America. So it's because the common law is going to be the same all around the world.
That's absolutely right. Yes.
This is a really now, and when you cite cases or do research, you do limit your research to cases from England when you're doing this book, or do you actually draw on decisions? Do you ever draw on a decision from Canada or New Zealand or anywhere else?
Yes, I do. I do, but very, very occasionally. If, for instance, if there's no decision in this country, or I'll tell you another case. I was telling you about exemplary damages. We decided to limit them way back in the 60s, it was, to these two categories I mentioned to you. Australia decided differently. They decided to retain exemplary damages effectively across the board. as I recall, and that decision, not following our decision, I cite in the book to say that not everyone agrees with this. Because the Australian courts are very good, and they've produced some very good decisions. And I've got an Australian case which follows what I say about consequential loss. I don't have to explain consequential loss to you, but the English courts, in my view, have gone wrong on consequential loss and decided it means something which it shouldn't mean. And the Australians have said that they think that the English law is flawed and what I say is correct. That's not bad either. So that's in the book, as you'd expect.
You have some new chapters in this.
You can't just go through. It's impossible to go through the whole law of all these countries, and therefore you have to limit yourself, basically, to this country.
You have some new chapters in this new edition. Is that right?
Yes.
And what are your what new categories are in the 19th edition that you didn't have in the 18th?
Well, sometimes some of the material was there, but it wasn't a chapter. It was just perhaps a footnote or something very short. Well, we've got a new concept of what's called vindicatory damages, which means where I've said to you damages are basically about compensation for loss. Exemplary damages clearly aren't. That's punishment. And vindicatory damages are about the person hasn't lost anything, but he needs an award of damages to show the public that he's been wronged. This happens with libel, for instance, or false imprisonment. So I have a chapter on this now because it's only become important, and cases have appeared on it in the course of the last few years. And I have a...
And I saw that the case, it would be a situation where somebody has been, let's say, lied about in the press, but everybody knew that they were lying about them, so their reputation wasn't really damaged, but yet it was a wrong. So this is in the nature somewhat of a punishment, right?
Well, it's in the nature of a punishment. As far as the defendant is concerned, I mean anything that is greater than the plaintiff's loss you could regard as a punishment, but it's not intended as a punishment so much as a vindication of the plaintiff's position. It shows. I mean, if he was going to lose that case, if they were going to say, well, you haven't lost anything because everyone knew he was lying, therefore your claim fails, that wouldn't look very good. And therefore they give him some vindicatory damages to show the public that, in fact, he has been wronged. You with me?
And the size of the award has to be consistent with how outrageous the lie was.
Yes, we haven't got many cases on it yet, so level of damages is not very clear. There's another area of damages which is just which didn't produce a new chapter in this edition, but produced a new chapter in the edition or the edition before that, and that's called restitutionary damages. And that's a case where the plaintiff hasn't lost anything, but the defendant has gained. I mean, I can put it as a simple case. For instance, if you have if you sell your property and you take a covenant from the buyer, who's a developer, he wants to develop the land, that he mustn't build more than 7 flats, shall we say, or 7 buildings on it, because you don't want your view too obscured. And he goes and builds 9. The case is that it hasn't really, having 9 buildings rather than 7 hasn't affected your view very seriously, and therefore you haven't lost anything as a result of there being 9 rather than 7. But the defendant has gained more than he should have done by the profits he'll make from the 2 extra buildings. And so the damages are given as not the whole of his profits, but as a percentage of his profits to the claimant, or as you'd say, plaintiff. And they are called restitutionary damages because you're restoring a benefit. In other words, they're based on benefit to the defendant rather than loss to the plaintiff. That's a new area.
We're here with Harvey McGregor, as the author of McGregor on Damages. It's the definitive book on damages in England, and he's a Queen's Counsel with many years' experience as a barrister. We are here on Justice for All, 1650 AM. I'm George Yates, your host. We're going to take a few short messages right here. We'll be right back.
The best of News Talk Radio, AM 1650 WHKT Portsmouth, The Answer.
Fink's Car Care is your place for all of your automotive needs. They handle state inspections, brakes, tune-ups, oil changes, transmission service, radiator repair. They have a wide variety of tires, and when it comes to your car, they do it all. Visit their 2 locations at 2711 Victory Boulevard in Portsmouth and 2236 South Military Highway in Chesapeake. For more, log on to finkscarcare.com and call 545-3573.
Old Town Tavern in the heart of Phoebus is your place for a great lunch and dinner, specializing in fresh seafood, burgers, sandwiches, salads, appetizers, and much more. Open daily, Old Town Tavern has live music, pool tables, darts, HD TVs, and a most pleasing atmosphere. Find them on Facebook. Visit 31 East Mellon Street in Hampton with plenty of parking in the back. Call 251-2636, 251-2636, bringing great food and great people together. Old Town Tavern, the locals' choice. Your family and their safety are your number 1 priority. Your home, your business, and quality of life provide peace of mind. Your security can be enhanced with the proper firearms and ammo from Battlefield Guns and Ammo. Never take anything for granted, whether you're at home or away. Call 757-410-7720, log on to battlefield-guns.com, and visit Battlefield Guns and Ammo at 240 North Battlefield Boulevard in Chesapeake.
Leaky faucet, refinishing old countertops? Hey, Gary Sullivan here. Perhaps you're restaining a deck or painting your living room. Whatever it is, let me help. I'm here to give you the tips you need to finish those pesky projects you've been putting off. If you're restaining, I have a tip for that. Can't get the paint off the hardwood floors? Got a tip for that too. I'm here to make sure that $5 repair doesn't turn into a $500 repair. Join me right here every weekend.
Saturdays at noon, Sundays at 9 a.m. on K-Talk 1650.
We're back on Justice for All. I'm George Yates with Harvey McGregor, Queen's Counsel. We're on a landline telephone call from, he's in Edinburgh, Scotland. I noticed in your, I was looking through your biography, Harvey, and I got it. You apparently were asked by the Law Commission, by the Scots Law Commission and the Law Commission in 1993 to produce a proposal for the codification and union of the laws of contract of England and Scotland. And
that's right.
And that was ultimately.
But it wasn't 19.
Go ahead.
Go ahead. You go ahead.
It was not adopted. You did it. You wrote the contract code in 1993. You proposed the abandonment of the English doctrine of consideration. Later on, it says here the European Commission. You disconnected me. Hello. And tell us about that. That's a pretty fascinating work you did. And what's that all about?
Well, the one thing you've got wrong is that it wasn't written in 1993. I'll explain about 1993 in a minute. It was written in the 1960s.
Oh. Well, then I need to make my changes to the Wikipedia entry. Good. I'm making some notes right here.
Well, did you put something about that in the Wikipedia entry?
No. I read this in Wikipedia when I was preparing for our interview, and I saw that you were asked.
Wikipedia says I wrote it in 1993.
It's called Contract Code 1993. No.
Yes. Is it called Contract Code 1993 in Wikipedia?
Yes.
I see. Well, they've got it wrong. I have to go back to explain to you. The reform of our law, I don't know how you work the reform of your law in the States, but we used to have what were called law reform committees who used to sit and study particular problems where the law was defective and needed improvement generally by legislation. In 1965, we had a man called Lord Gardner, who was the Lord Chancellor, and the Labour government got in, and they made him the Lord Chancellor. And he said, "I'll only do that if you set up what's called a law commission." And the law commission is a permanent body which looks at the reform of the law and has done great work since 1965 on to today, and it's still operating and has been very valuable. And I was asked to join the Law Commission, but I didn't want to join it because I wanted to be at the bar, and also they wouldn't have paid me very much money. But the first item in their first program was they were thinking of codifying the law of contract, a very difficult problem, a very difficult task, rather. And what they saw was they couldn't really do that by committee with the people in the Law Commission, and therefore they asked me if I would draft it. And so in the course, so this is something else I'm doing as well, as teaching and being at the bar. I spent a lot of time between 1966 and 1970 writing my version of the codification of the law of contract. And it was combined English and Scottish law. That's one reason. And generally speaking, I kept to the Scottish rules, which doesn't have consideration, for instance. And we met and discussed my drafts right through those years. And we went up to Scotland, discussed it with the Scots, and eventually it got finished. But the government wasn't keen to enact it for reasons that difficult to say. But I said to the Lord Scarman, who I mentioned to you earlier, in relation to my becoming a QC, he was one of my referees. He headed up the Law Commission, and he said, I said, well, couldn't we publish it? And the Scots, who I think Lord Hunter ran it, said no. They vetoed it. The reasons aren't very clear, but I suspect because they felt if we had a codification of the laws of Scotland and England, Scotland would lose out, as it were, being the smaller country. So I was rather cross about that, and I didn't just want to put it in a drawer and not have it published. Many years later, there was an Italian dynamic chap who was dealing with the European contract and trying to get the whole of the law of contract codified for Europe. And somebody said, and he said, well, of course, we know that England is not very keen on codes. And the person who he spoke to knew me and said, oh, well, I think I know someone who has done the codification. So he said, tell me who he is, bring him out. So I was taken out in grand style to Italy, to the University of Pavia in the north, and we had many, many meetings and discussions about it, and he to do the European code, he used the Italian code and what he called the McGregor code as the models. And so eventually it was published in 1993 by the Italians in Milan. And so it wasn't published in England, it was published in Italy. And eventually I got it published in the Edinburgh Law Review. But it hasn't become law in England. But it is regarded as if I can say so, a fine work. There was a very important French academic, now sadly deceased, Professor André Tunc, who reviewed it very favorably in the International Encyclopedia or International Review. I can't remember the exact one. And one of the things he said about it was not only was it well constructed, etc., but he said it is readable. You see, because so much of our statute work here is written, I don't know quite by whom, but they are so badly written. They go into detail and what you could say, and I would say in a very short number of words, they say in 1,000. I don't know what your statutes are like. Are they easily read?
It all depends. Some of them are completely indecipherable, and others are easier to read. It's all going to depend. But for the most part, they're not well written, I think. But
yes.
But yeah, the entry does mention that it was published in 1993 by an Italian university. And
that's correct.
Yeah,
yes.
so the entry is correct that you were commissioned to do it.
It was an Italian publisher. It wasn't a university.
Okay.
I mean, they're connected with the university. Geoffrey, they're called.
And now, and it apparently was. There was the European Commission expressed an interest in adopting it as the basis for the EU-wide law of contract, but then
that's right.
But it hasn't quite been pursued since then. But it still is out there, and it's
out there.
And now, does that need to be updated from time to time? I guess at some point somebody could still take that out of it. You didn't leave it in the drawer; it's out there, and it can be used if someone chooses to adopt it.
It can be used, yes. Well, of course, you can update these things, and there are various things I've written. Another important thing I've written is there's a volume called the International Encyclopedia of Comparative Law, and I got a job writing that, a chapter on damages, just on personal injury damages and fatal accidents. And that was a great work. It involved my studying mainly all the systems of the world. And in fact, when I got another degree I've got a Doctor of Civil Law, which is the highest Oxford degree in the law. I think we mentioned that when we talked the other day. And you have to submit written work for that. So obviously I submitted the damages book. But I also submitted this chapter in the International Encyclopedia.
1972?
1972, yes. I was told by a colleague of mine that the committee who awarded me the DCL, had said that I would have got it on the strength of this damages article on its own, because it was so widely, it covered the ground so well. And I had a lot, and I took it on because it was very well paid. When the invitation came, I thought, well, I was staying with someone. She read it in the morning, and she said, "You've been asked to write this." I said, I don't think I want to write an article. But she says the payment it was very high per page, and so I took it on, and then I was given an allowance to get information from countries I didn't know a great deal about, like Russia, know about their law. And so what you could do is do a questionnaire and send it to them and say, for X £1,000 or X £100 it would be, would you answer these questions? So I did that with a number of countries, and I found that some of the answers were pretty good, but some weren't, so they hadn't paid too much attention to it. They just collected the money. And even when they were good, there were always other questions you wanted to ask when you read what they'd said. So I came on the excellent idea, instead of spending the allowance on fees to these people, I knew that if you went to talk to them, they'd be happy to talk free. And so I spent the money on airfares, and I went to Germany, Munich, I went to Rome, I went even to Mexico City, and I was going to go to South America, but the South Americans never replied. They're not very good at that sort of thing.
In the 53...
So that's another of my important works.
Back to your book on damages, 53 years since 1961 edition. I'm sure you've seen a lot of changes in legal research methods since 1961. We didn't have computer research back then, and all through your various editions that you've done. Who helps you write this book? How do you make sure that you have all of the authorities? And what process do you go through to make sure that you are current and you keep your book up to date?
Well, we have all these computer advantages now, and we have, you know about Westlaw, I suppose.
Of course.
And we also have something called Lawtel, which Chambers subscribes to. And so, which looks at cases, all the cases come out every day. And as a subscriber to Lawtel, what one does, if one wishes to, and I have done it, is you ask them to let you have all cases dealing with damages, and you can't limit it to damages, because quite often the head note in the case doesn't mention damages. So you put in things like contract and interest and et cetera, et cetera, et cetera. So every morning there comes from Lawtel to me the cases which are related to damages of the day before. And that prevents an enormous amount of research, because you get all the cases even even before they're reported. In the old days, you had to go and look at all the law reports in various volumes. Various, the All England reports, the official reports, the weekly reports, the building reports, etc., etc. So that has improved things enormously. One of the difficulties is legislation changes and rules of court change, and so I have a very efficient girl, well, she's a woman rather, in my publisher's company, who I sent her a questionnaire which said, has this statute been amended or dropped or whatever in the last 5 years? So that's a bit of research done. But otherwise, I read, and the cases that come to me from Lawtel, when they involve damage, I read the whole thing. And so I said in my initial edition, and people have been very surprised by it, that I have read all the cases which are cited in the book. And since there are now about 10,000 cases cited, I've read quite a lot. So I'm what you might call a rather unusual person in this respect.
Well, you really are, and it's really quite remarkable. So you get these cases every day from the advanced sheets on your computer from Lawtel, and then do you begin categorizing them in your book under where they might fit in to your next edition,
That's
so that
right.
you can keep up with it on a
Yes.
daily basis?
Yes.
And so that way, when it comes time to do the new edition, let's say, when's the 20th edition coming out?
Well, they want them every 4 years now, but I never seem to be able to do it without more like 5. I would say 2019.
So right now, let's say this book came...
If I'm still around, of course.
Oh, of course you will be.
But well, you've read the last paragraph of the preface, haven't you?
I did. So let's
Which
hope...
suggests I might still be around.
Let's hope the preface
I think if my mind and my memory is still functioning at 88, it's likely to go on for a few more years. But who knows?
But you're preparing it. What's fascinating is you still are preparing for the next edition. So let's say a Monday morning or Tuesday of next week, you'll be checking your Lawtel in the morning and pulling the cases having to do with damages.
No, I haven't started yet. I'm having a rest after the publication. Publication's, after all, only been out for a month and a half. And I just, the Lawtel, they're all on my computer, and I'll go back and start looking at them in a few months' time.
And when
because I do supplements. You familiar with the supplements I do?
So you'll do a pocket part.
Yes, and it's a small, 100-page thing, in which you just say insert in paragraph so and so, or substitute something and deal with the cases. And you do a supplement every year. That's not so much work, obviously. So they want a supplement in 2015. And of course the supplements are quite useful when you come to write the next edition, because it means you've got all the work in relation to 2015, 16, 17, and 18 for the publication in 2019, if that's when it's going to happen.
Is your book the kind of book...
I'd like it to happen in 2020, because it sounds a very good date.
Is your book the kind of book that would be in virtually every chambers? That would...
Oh, yes.
And it would be one of those books that maybe one barrister might buy and share with one of his fellow barristers because of its price, or is it one that they all have to buy and carry to court with them?
Well, we all have a chambers library, so the chambers library will buy a copy, but some chambers buy, so many people can buy 3 copies or 4 copies. And I can tell you there's one legal shop that sells them all in just near the Temple, bottom of Chancery Lane, Fleet Street, which you probably don't know. I was told by the headsters that on the first day when the book was published, 100 people came in and bought it at $900. That's not bad, is it?
And does your publisher give you a nice healthy chunk of that, Harvey?
I get a 15% royalty. which is very high.
Well, that works out pretty well. So,
I have the best. I've got the best contract in the business.
And I think I asked this question. I'm not quite sure. Do you have anyone besides the young lady you were talking to, the girl that you said do you write this book all by yourself? Do you have any help?
Well, I write it all, but that's what's unusual about me. The only part of the young lady is that two of my members of chambers asked me back before the last edition, but two, I think, back at the beginning of the century. They would very much like to help me because they could. It was unusual, as I've said, for one person to be writing a book of this size. And I said, well, we might try and do it together. And so I suggested we go and look at a particular chapter and read it and think about it, and then come back and discuss it. I chose that chapter on mitigation of damage, which is now chapter 9, I think. And then I realized that you can't write by committee. And then I had the excellent idea of giving them a few chapters to write, one chapter for one, because two things had happened since recently in this century, or about 2000. We have passed a Human Rights Act. I'm sure you're familiar with human rights, are you not?
Yes, and you have chapters on that in your book.
Yes. The human rights is entirely outside the normal law of damages for contracts and torts. And so it was an entirely new field in which damages, I may say, don't feature very much. They tend not to give damages, or if they do, they're not very high. So I had the idea of giving, so it's outside the normal law, the big law of substance of the law of contract, general principles, tort. And so I arranged for one of these two chaps to write the book on human rights. Now, there were a couple of chapters on procedure, which I had written, and the procedure rules are all changing. We have a new system of called civil procedure rules, taking the place of rules of court, and they were reforms in about 1998, done by the then Chief Justice Wolf. They're called the Wolf Reforms. So it meant that all the procedural rules had changed. There were new numbers, new. The substance didn't change all that much. And so I thought, well, I haven't investigated the new rules. I'll get the other chap to update and the procedure chapter.
Well, that's great.
And so he's taking that on. So you'll see in the book. You don't have the book there, probably.
I've got the book here.
If you open it at the front, on the title page, you'll see it says McGregor on Damages by Harvey McGregor, and then below it'll say the chapter on human rights provided by Martin Spencer QC, and the chapters on procedure updated by Julie Pixon QC. You see that?
Yes, I do. Hey, we're going to have to go, Harvey. This has been the last.
Let me just say it at the end of that. That still leaves the whole of the substance of the book with me. I have written 47 chapters out of 50.
It's an incredible
So on
work.
that note, we can.
I want to thank you so much for being here today. It's been an honor for you to be with me today, Harvey. Thank you so much for being on the show.
Well, I hope your listeners have enjoyed it.
I'm sure they have. Thank you so much. And that's
anyhow. Sorry.
Yes, sir. Thank you.
Are we still on the air?
No, we're still on the air. I was just going to sum up. Thank you so much for listening to Harvey McGregor today. This is George Yates with Justice for All, 1650 AM. You can listen to the whole of the interview with Harvey McGregor on my website at www.ghylaw.com. He's the author of McGregor on Damages, which is the definitive book on damages in the common law countries. And actually, we'll have some persuasive authority here, even in America. Thank you so much for listening to Justice for All today. We'll be back next Saturday from 2 to 4 p.m. This is George Yates.